Is that any better? Is that any better? Okay. This delay thing's kind of weird. Hey, Classy. Man who got me into all of this. It's your fault. Oh, man. Okay. This is so strange. All right. Oh man, you're gonna be paying for those Fonnie Willis fines soon. So, oh, okay, all right. So I've been meaning to make a video about this. I might as well do it now, I guess. Still can't get used to this, but yeah. So this is the this is so strange. This is the order entered by Judge Cannoni in the Karen Reed case that imposed the gag order, and although the state requested sanctions, they weren't granted. And I thought this one was interesting because I'm not sure that there were any violations, and there's a little bit of shadiness, shady in a variety of senses, I guess, in this order, and I just wanted to run through it. And I guess I'll start reading. As you can see, we don't need to go through all this. Start here. For the court, two motions: the Commonwealth's motion to impose sanctions, and an oral motion made by the court, made by the Commonwealth to the court, reviewing its prior motion to restrict extrajudicial statements, out-of-court statements that have a substantial. This is actually important. This is the standard here. A substantial likelihood of materially prejudicing these criminal proceedings. I feel like I forgot how to read. Let's see. Ooh. I realized this video is kind of stretched. Hold on a second. All right, that should be better. Sorry about that. Let me see. So, yeah, so as you can see, the court denies the Commonwealth's motion for sanctions, so I'm not going to cover that. And it allows the motion for limiting the extrajudicial statements. This part's just the sanctions. I'm going to skip through this. And again, few, if any, interests, this is quoting the Supreme Court, few, if any, interests under the Constitution are more fundamental than the right to a fair trial by impartial jurors, and an outcome affected by extrajudicial statements would violate that fundamental right. And you can just ignore these highlights. They're mostly just notes to myself. And again, they're just restating the standard, and it emphasizes the importance of freedom of speech, even within the context of those limitations, or within the context of the court's right to impose limitations on speech. That, even though it has the right to regulate speech, the regulation of attorney speech is limited. It applies only to speech that is substantially likely to have a materially prejudicial effect. So again, restating the standard. And let me see, essentially just restating the standard again. But what I want to get through is the examples of the rules violation that Judge Cannoni used. He says, in June 2023, the Commonwealth filed a similar motion to essentially the same one that she's ruling on now, and a similar motion to prohibit prejudicial extrajudicial statements of counsel. It says the court denied that motion, including that no trial date had been set and that this minimized the likelihood that those statements would materially prejudice the proceedings. And I have that order here. And so that was entered on July 31st, 2023. And that will actually be important in a second. So again, the request restated the order. So let me see here. The first example is, let me see, that the Commonwealth gave of the violations was, the first one's the interview conducted by Gretchen Voss of both Karen Reed and Alan Jackson at the Omni Seaport Hotel on July 13th, 2023. Now remember I just said, the order denying the prior motion was on July 31st. So this would have been before that order was even entered. So anything done on July 13th wouldn't have been violative of an order entered on July 31st. So that wasn't a violation of any gag order or order imposing limitations on those kinds of extrajudicial statements. And then the middle note there was part of the order. Okay. And it says, I'll get to the second one later, but as she said, based on these interviews and defense counsel's consistent publicly reported interactions with reporters and bloggers throughout the first trial, the court agrees with the Commonwealth that an order limiting extrajudicial statements is both appropriate and necessary to ensure a fair and impartial trial. And what I find interesting about that is she's saying it's appropriate and necessary. That's not really the standard, remember, because we're supposed to be looking at whether there's a substantial likelihood of materially prejudicing the proceedings. So there's no finding that there's a substantial likelihood. It's necessary to ensure a fair and impartial trial. But the court really can't do anything to ensure a fair and impartial trial. That's kind of it's a little bit of a red herring, a little bit of a misstatement of the standard. The court didn't really identify what exactly the prejudice would be, and that there's a substantial likelihood of it, but I'll keep going. And so the second one here is, the second example is the Fox 25 interview that aired on February 17th. And, oh man. Let's see here. Okay, yeah, so in the Fox 25 interview, Jackson claimed that although individuals in this case know what really happened, they're not talking. So that's just objectively true. There are individuals involved in the case who know what happened and are not talking. Because nobody's admitted to doing it, so just objectively speaking, that's true. It's also not naming any individual witness, or it's not even necessarily referring to people who are witnesses, or who will be called as witnesses. And the funny thing is, although he says they're not talking, let me read this here. The second point is, witnesses in the Albert home the night of January 28th had obtained lawyers for self-preservation, which implies that they're not being truthful in their statements to law enforcement about what occurred. So if they're not talking, then how is there an implication that they're not being truthful in their statements to law enforcement? Those are just completely at odds with each other. Let me check the chat. I guess I can just answer your question on the stream rather than typing in chat. No, I don't think the gag order will affect the documentary. I don't know how much involvement the defense team would have had in the preparation of the documentary, but what's done is done, and it's out of their hands now. So I assume if HBO has the footage, it'll just be used. Oh man, 20 people here already? I should have prepared more for this. Let me see. Okay, I forgot where I was, but okay, so we were talking about I'm going to jump back a little bit. We were talking about the Gretchen Voss interview, the Boston Magazine Gretchen Voss interview that happened on July 13th, 2023. And the court says, based on these interviews, defense counsel is consistent. We read this already. In trial. During the Voss interview, the defendant, this is important, the defendant with Jackson at her side told the reporter, so this is Karen Reed speaking. This isn't a lawyer speaking. This isn't Jackson speaking. Told the reporter about witness testimony from the defendant's sealed grand jury proceedings. Specifically, while discussing Voss's recent visit to the Waterfall Bar and Grill, the defendant stated the bartender who works there had testified before the grand jury. I mean, that's the Waterfalls where that was the bar where they were drinking before the night of the incident, so it's not some big revelation that the bartender working there that night would have testified. It's also kind of funny there's the bartender who works there, implying that there's a single bartender who works there and that this person would be identifiable based just on that. But in any case, after further conversation, the defendant then told Voss about the substance of the testimony before the grand jury. And then this is where things get a little shady. It says the requirement, not identifying the requirement, but the requirement that grand jury proceedings remain secret is deeply rooted in the common law of the Commonwealth in order to protect the process from extraneous influences, protect individuals from notoriety and disgrace, protect witnesses from intimidation, subornation, and encourage the free and full disclosure of information concerning commission of a crime. And so it's to this case here. And as you can see, I have the case here. And this is the part that's being referenced, saying, and it kind of explains the context of the case, of this case, and why it's not applicable to the Karen Reed situation. It says, grand jury secrecy is designed to protect the grand jury from extraneous influences. And let me see. This part, I believe, is omitted from the original. Yes, it says, in order to protect the process from extraneous influences. And Canoni's order, but in the case it says to protect the grand jury process. So, grand jury secrecy is designed to protect the grand jury from extraneous influences that have the potential to distort the investigatory or accusatory functions of the grand jury. So this case is about the function of the grand jury, whereas in Karen Reed's case, that had been over, I believe, a year prior to the date of this interview. So the grand jury's gone, and this case isn't really relevant. But anyway, such extraneous influences include the news media, of course, members of the press are in attendance. The requirement of grand jury secrecy is also designed to protect individuals from notoriety and disgrace unless probable cause is found to indict them. So that, for this provision, the statement, when they're trying to protect individuals from notoriety and disgrace, they're talking about the defendant. And that part is omitted here, saying protect individuals from notoriety and disgrace, not clarifying that it's the defendant who's making this statement in Karen Reed's case, and she does need to be protected from her own statements. That doesn't make any sense, and omitting that from the reference source is kind of misleading. Let me see. Then protect witnesses from intimidation. Let's go back here. Yeah, protect witnesses from intimidation, subornation. Again, that's within the context of grand jury, not a trial, so it just doesn't really apply here as far as I can tell. And then the last provision, to encourage full and free disclosure of information concerning the commission of a crime, and to allow the utmost freedom of deliberation to the grand jury. Again, that has nothing to do with this case. So this Judge Canoni's invocation of the law sort of protecting the function of the grand jury is kind of misplaced, misguided. It doesn't support a gag order with respect to a public trial. Let me see here. Oh yeah, this was another funny little thing. At the hearing on the motion, Prosecutor Brennan also stated that Yannetti appeared on court TV, falsely representing the subject of the federal investigation. No, court TV played a clip made on a Zoom hearing in court. It's contrary to the Commonwealth's representation. The statements are not extrajudicial and thus not considered for this motion. The funny thing is, in the first, that was my notes itself. The Commonwealth's motion, this is a year prior, the Commonwealth's motion also refers to statements made by the defendant's counsel in court, as well as in court filings. Such statements are not extrajudicial. So they did the same thing last time. They did the same thing, I think it was a year ago, or 2 years ago, when they made this motion. So it's extra inexcusable to be making this mistake again. If you include statements made in court the first time, you need to not make that mistake again. And let's see, Judge Canoni also refers to these two authorities here. So I'll start with this one, 13D. Let me see, and again, this refers to again, this is about grand juries distributing transcript or description of grand jury testimony. It's the title of the section. It says, nothing in this section shall be construed so as to prohibit any person performing. Ooh, wait a second, let me go here. Yeah, so nothing in this section shall be construed as to prohibit any person performing an official function in relation to the grand jury from disclosing a grand jury transcript or description thereof. So this is limited to any person performing an official function in relation to the grand jury. So that doesn't, the defendant and the defendant's attorneys wouldn't be at a grand jury. They certainly wouldn't be performing an official function. So this section it doesn't apply to them, first of all, but hold on a second, that's not right. Let's see. Matt. Yeah, Matt, it's the or Matthew, it's the gag order that was imposed this week. Hold on a second. Let's see. Okay. Trying to get the chat up so I can see what you're saying. Okay. Okay. So I'm going to come back to this actually. I discussed that in a second. But Rule 5D of the Massachusetts Rules of Criminal Procedure ensures the secrecy of the proceedings and governs disclosures. It specifically prohibits anyone other than a person, it's the same language I just read, a person performing an official function in relation to the grand jury from disclosing matters occurring before the grand jury, except in the performance of his or her official duties or when specifically directed to do so by the court. That's the opposite of what the rule actually says. Five. So 5D. Okay, so it actually is, we can skip this part. A person performing an official function in relation to the grand jury may not disclose matters occurring before the grand jury. So a person basically, and if you're a lawyer appearing before the grand jury, you may not disclose it. So compare that to what this says. It prohibits anyone other than a person performing an official function. This is Canoni's order again. It specifically prohibits anyone other than a person performing an official function from disclosing matters occurring before the grand jury. That's the opposite. It prohibits people who are performing an official function from disclosing. Let's see. It says a person performing official may not disclose. So the prohibition is directed towards the person performing the official function. So it's the it's inverted. And then the rule goes even further, saying no obligation of secrecy may be imposed upon any person except in accordance with law. So this can't really be used to impose a duty of confidentiality or some kind of duty of secret or obligation of secrecy upon defense counsel, because there may be other ways to do that, other sources of authority, but this isn't that. Let's see. Okay, and earlier I mentioned that it was Jackson. It was Karen who was making the statements to Voss in that interview. It says, okay, although Jackson did not himself disclose information about the grand jury proceedings to the reporter, he had two opportunities to intervene to prevent his client from disclosing such information. That's a complete red herring. Jackson didn't say anything. That's what matters. You don't have to. Yeah, no cat. He didn't say anything. That's the point. And the judge is trying to impose an obligation to speak up, to prevent his client from speaking, and that's just not the sort of thing that would fall under the ambit of a gag order. Instead, he sat idly by while his client disclosed to the reporter the testimony given in grand jury proceedings. And remember, the court still hasn't actually identified or explained why Karen isn't entitled to discuss the testimony given in grand jury proceedings. There may be one, but that hasn't been identified so far. Let me see. Let me see. Okay. Additionally, during the interviews with Voss and Fox 25 News, Jackson disparaged witnesses in the matter. In the Voss interview, he specifically referred to two witnesses liars. I think that's supposed to be as liars. Two witnesses as liars. Okay, well, maybe they are liars. We don't know that. Anyway, statements commenting on the character, credibility, or reputation of a witness are more likely than not to have a material prejudicial effect on the proceeding. Again, that's not good enough. 3.6 here. Actually, don't need that. It says more likely than not to have a material prejudicial effect. But as we discussed up here, there needs to be a substantial likelihood, not just more likely than not. So more likely than not isn't enough by itself. There needs to be something greater than that, and there can be, but the court needs to explain that. And they're just not really doing that kind of fact-finding. Can she enforce gagging Karen? I believe she can, but it wouldn't look like this. There would need to be some kind of other authority for her to do that. These, like she's citing to, let me see, like Rule 3.6, for example, this is just only binding on lawyers. There's nothing that, it has nothing to do with Karen. Rule 5 is about grand juries, and this is also directed towards people performing official functions. That doesn't apply to her. And I guess this could possibly, but there's nothing in this order to really explain why Karen is attempting to interfere with criminal proceedings by these statements. She's not tying it all together, but I'm sure it's possible for her to do so. Okay, touch on this part. Ooh, okay, this is one other one I want to talk about. Footnote 3. The course also notes that Jackson had a conversation with Voss during which he revealed information that had been turned over by the Commonwealth in discovery but not yet made public. In that discussion, Jackson acknowledged to the reporter that he was not permitted to disclose the information that he received in discovery and told her she could not publicly disseminate the information until it was put in a court motion. Attorney Jackson then proposed a way to make the information public in an unrelated court hearing so the reporter could put it in her article before publication. So what's interesting about that is again, remember the standard is substantial likelihood of material prejudice, and if the reporter can't and doesn't put the information in public before the reporter is entitled to, then the reporter's not going to say anything or publish anything that they are not entitled to publish. And so there's not really going to be any prejudice caused by Jackson's conveying that information to the reporter, because it's going to remain confidential until the reporter is no longer bound, until that information can't properly be made public, until that information hasn't already been made public by way of a court filing. So there's just no possibility, there's no prospect of prejudice in that case. Now, it's possible that Jackson could be, there's a different kind of misconduct by publicizing private information, under false pretenses in an unrelated court hearing, but that's just a different question. That's not about the prejudice of this specific communication between Jackson and Gretchen Voss. Okay. Okay. So this is kind of circling back to the fact that a lot of these statements were made before July 31st, 2023 ruling I mentioned earlier. In the decision on the Commonwealth's first motion to prohibit extrajudicial statements, the court stated that defense counsel's statements to the media had at times arguably crossed the line of permissibility under Rule 3.6, which again is only applicable to lawyers, but concluded that the risk of prejudice was minimized by the fact that no trial date had been set. I was going to do this as an article first, so I was saving my images to post on the side. I wouldn't normally have Anchorman references on the side. With trial now imminent, and with the above-mentioned examples of improper statements made directly or indirectly by the defense counsel, the court's no longer satisfied that the less the restrictive alternative to the order previously given, the reminder to counsel that they are bound by the ethical and procedural rules is sufficient to ensure a fair trial in this matter. But again, everything said to Gretchen Voss was prior to that order, and that can't support this conclusion, that it's no longer sufficient. I don't either, Tara. Let me see. Court finds there's a substantial likelihood that continued comments about witnesses and evidence in this case by counsel in the future might well taint the jury pool. That's also not good enough. Might well. I'm going to start from the beginning. So the court finds there's a substantial likelihood, okay, that continued comments about witnesses and evidence in this case, and this is a second condition, might well taint the jury pool. So it's kind of a head fake. They're saying substantial likelihood that there might be prejudice. That's why this meme comes in. That's essentially what she's doing. There's a substantial, it works every time, 60% of the time. There's a substantial likelihood that it might taint the jury pool, rather than just the standard up here. Here we go. That there's a substantial likelihood of material prejudice. Not that there's a substantial likelihood that there might be material prejudice. And let me see. Yeah. So therefore, an order restricting such statements is now both appropriate and necessary. That doesn't make sense. As we just said, there's substantial likelihood that there might be an issue. It is not a substantial likelihood of material prejudice. So this statement in the order doesn't follow from the premise. And yeah. Man, I've been trying not to watch the hostage video because it's just, I know I'm going to hate it. I watched the first sentence and I was already upset. You should watch that next. Okay, that was rambling and incoherent. I hope people like that somewhat, though. I am going to make an actual full planned up video at this on this at some point. With a little bit more preparation. Hopefully it makes more sense. But yeah, this was supposed to just be a test. I'll probably come back with a full video, full stream tomorrow maybe. But I do actually have some regular work to do, so I have to go right now. And I will be doing the Good Jerk stream, or the Good Jerks, the Young Jerk stream, I think a week from today. Thanks, Tara. I still want to type in chat when I see stuff in chat. I don't understand that, like, I'm the one that's actually on the stream speaking. I don't know how Classy does it, man. But yeah, no, thanks for tuning in. I appreciate it. And God, this is so awkward. But yeah, I'll be back soon. Thank you all, and have a good night.